Welcome back to Ask a Lawyer. Mark, today I'd like for you to educate us a little bit about an on-the-job injury. If someone trips and falls or something falls on them while they're at work, let's talk about the repercussions of that.
Well, the workers' compensation system is a no-fault system. It's set up such that there's a rapid provision of benefits to an employee when they are injured on the job. When I say it's no fault, that means that it doesn't matter if the employee was negligent or they stepped left instead of stepping right. If the injury happens and there's not alcohol or drugs involved in the incident, then the medical bills and lost wages of the employee are taken care of by the system. That's how it's supposed to work.
So if someone is impaired, though, that would be something that would be aside from this? Is that what you're saying?
Alcohol and drugs will absolutely affect your entitlement to workers' compensation benefits.
Okay, so let's go back to the situation where somebody trips over a box and breaks their hip at their place of business. What else can happen with that, with work comp claims?
Well, from time to time when we are evaluating workers' compensation claims, folks don't know that there may be other claims involved. The most frequent example is somebody calls us for a workers' compensation case. They're driving their car or their employer's car, and they're on the job making a delivery, and somebody causes a motor vehicle crash. The way the workers' compensation system is supposed to work is it takes care of their lost wages and medical benefits. But that employee may also make a claim against the insurance of the person who caused a motor vehicle crash. We call that a third-party claim.
Which is not involved at all with the work comp situation, is that correct?
It is a separate claim. It's a separate claim against the insurance company and the person who caused the crash. Now, it would be incorrect to say it's not involved at all with workers' comp, because when workers' comp provides benefits because you're injured in a motor vehicle accident, and then you recover monies from the person who caused the accident or their insurance company, the workers' compensation carrier is going to get some of their money back.
Ah.
And that's called a workers' compensation lien.
And that's when it gets complicated.
Well, not really. I mean, we have to recognize that that lien is out there. The workers' compensation folks provide benefits to the injured employee. We, on behalf of the client, are making a claim against the person who caused the accident. So at the end of the day, if we're able to resolve that matter for our client, we talk with the workers' compensation carrier about resolving their lien. And there's some things they have to take into consideration. Number one, our client is paying attorney's fees and costs. There may be limited insurance coverage that they can recover from the person who caused the crash. Or our client may bear some responsibility in the crash. That's called comparative negligence. So the workers' compensation carrier has to take all those things into account in terms of determining what they get to satisfy their lien. Short answer is, if they provide $100 in benefits, they don't get $100 back. It's some portion of $100 that they get back to satisfy their lien.
In this particular example, we're talking about a car crash and the other person involved. What if it were something like a product liability type of a thing where the crane didn't work properly, where they've got something against their employer, you know, the work comp claim against their employer, but also the company that made the crane that slipped and they fell? The
same general principles are applicable. It doesn't necessarily have to be a motor vehicle crash. Anytime that you as an employee have a claim against somebody other than your employer for injuries that you sustain on the job, that's called a third-party claim. And at the end of the day, if you resolve that matter, then your workers' compensation carrier is going to get some of their money back. Oftentimes, when people are injured on the job, they assume all I get are my workers' compensation benefits. Workers' comp does not pay pain and suffering or non-economic damages. Your third-party claim, those are available to you.
Let's go back to that pain and suffering. I think people assume that work comp does cover that.
Does not.
So you break your arm and you damage for the rest of your life, then you just live with it. I mean, you're not compensated for that.
Well, you're compensated in terms of primarily medical bills as a result of that, and most workers' compensation carriers have agreements in place with major hospitals and healthcare plans where if there's a dollar billed, the medical provider will take 60 cents on the dollar to provide the medical care. So the system is not going to pay for the inconvenience, the suffering that you go through in going through some type of incident where you suffer an injury. Third-party claims, tort claims typically they're called, or personal injury claims, you can make those types of claims for non-economic damages or more commonly referred to as pain and suffering damages.
So when there's a third party involved in this, the best thing to do is contact an attorney to go through the process with you.
Well, if there's a third party involved, it may be totally the fault of the employee. The employee causes some type of injury and they're totally at fault for the injury. You can look at a third party claim, but you got to prove that the third party was negligent. If you can't prove that they were negligent, there's no third party claim there. In that instance, the only thing they'd have available to them would be their workers' compensation benefits.
I see. Thank you, Mark.
You're welcome.